right. Well, thank you very much for joining us at these very, very unusual times and for joining our MILI webinar on a topic not directly related to COVID-19. I know this is what we're all living and hearing about these days, but we're very much looking forward to this webinar as, of course, you know, ACA and insurance availability and access, that's one of the key provisions where we need to think about at these really difficult situations as well. So today we are very fortunate to have Ralph Hall, who will be discussing with us his views and perspectives from Washington, D.C. and other areas on the constitutionality of the Affordable Care Act. Just a very quick introduction. I am Pınar Karacamandeç. I am the Academic Director of the Medical Industry Leadership Institute. And our hope throughout this time is to bring you content, COVID-related or not COVID-related, and try to keep some normalcy in our daily lives and keep talking about some of the very, very important topics that surround the healthcare industry. So I would like to introduce Ralph Hall, who is a principal at Leavitt Partners, a health policy firm, and Ralph works in association with the Washington, D.C. office of Leavitt Partners, and in his role, he provides consulting services to the clients in the areas of FDA statutes and regulations, regulatory compliance, as well as healthcare policy and legislation, and particularly in the application of those regulatory systems to the medical device and pharmaceuticals industry. Ralph has a very rich background in drug and medical device regulation and corporate compliance matters and makes him one of the nation's foremost experts. So we are extremely grateful to have Ralph here. And Ralph also serves as a professor of practice at the University of Minnesota Law School, and he is our faculty for MILI's Healthcare Law and Regulations class as well, and I know he'll say a little bit about that as well. Ralph received his BA from Indiana University and his JD from the University of Michigan, where he was a Weymouth Kirkland Scholar. And I will pause right there and introduce Ralph to take over and discuss with us the ACA constitutionality. Thank you, Ralph.
Thank you. Appreciate everybody's time and attention on a Monday afternoon, particularly in these quite unusual times. Let me just provide a bit of background here of what we're going to try to get done today and the purpose for it. Obviously, everybody's attention on a day-to-day basis right now is on COVID-19, which has a plethora of issues and challenges across many disciplines. But all of this takes place in a context of a broader regulatory structure. Obviously, healthcare is heavily regulated at all levels, whether it's FDA, Medicare, Medicaid, CMS types of issues, the insurance markets, etc. And understanding this intersection is important. As people talk about various statutory or regulatory or sub-regulatory approaches to the COVID-19 situation, they're dealing with a pre-existing regulatory system. And one of the key aspects of that system is the Accountable Care Act. And so what we're going to do is talk about this intersection. This is part of a broader effort to try to link the world of law, statute, regulation with the world of business, of healthcare in particular. And as Pınar mentioned, we do have this MILI course, 6421, which is essentially fundamental of healthcare laws as they apply to the healthcare business. The objective of this course is to provide a structure for actual or prospective healthcare managers and leaders so they understand healthcare law and how it impacts business strategy and business decisions. As part of this, we get into current healthcare policy challenges. The course is offered in the fall. Obviously, we are not done putting it together for this coming fall, but I think there's a fair bet there'll be a lot of discussion about COVID-19 and all of the issues that surround it. Let's start off with just a very high level where we are. The Accountable Care Act, or Obamacare, depending on what you want to call it, has been challenged for many years in many fronts. There have been multiple, generally unsuccessful efforts to repeal it. There have been some modest changes. And we start kind of the legal intersection here in 2012, and we'll get into detail in a minute, when the Supreme Court first reviewed the constitutionality of the Accountable Care Act. And now the Supreme Court gets a second crack at this, where this fall they will again have an opportunity to assess the constitutionality of the Accountable Care Act. So what we want to do here is get a feel for what the current legal status is, so you know what the issues are, what the key issues are here. There are some constitutional and there's some statutory. And at the end, start to do a bit of thinking about the impact that different rulings could have on health care. And as part of this, also make sure people have a feel for the timing of when we expect Supreme Court rulings. As I think about this, there are 5 rounds. You think about this as a boxing match, perhaps, but 5 rounds of activities. And we'll get into each one of those and see how they fit together and how this builds to where we are today. I was a history major, and so understanding the history here is actually critically important to understanding the current legal issues that the court will be deciding. So how did we get here? A bit of a timeline is interesting. 2009, President Obama takes office. The Democrats have a majority in the House and in the Senate. In the Senate, what is important is they have a 60 vote, 60 to 40 majority. That's a so-called supermajority. What that means is they can shut down filibusters. And so that gives them much greater power just to enact any legislation that meets their particular needs. And one of the key aspects was to develop a comprehensive healthcare legislative package, and that they were working on. Ironically, Senator Ted Kennedy, who had long been active, very active in the healthcare area, died in August of 2009. Now, apart from the loss of a well-known political leader, this also put the Democrats' 60-vote supermajority at risk because he is now gone. Now, for Massachusetts, they appointed a temporary person to fill that slot until there could be another election. That individual, because Massachusetts had a Democratic governor, was also a Democrat. So at least for some time, they retained that 60-vote supermajority. And this, as I mentioned, gave them substantial political leverage. In Q4 of 2009, the Senate and House are considering versions of what we now call the ACA, and they both passed similar but not identical healthcare reform legislation. The fact that it's not identical is critical. The expectation that everybody had was in conference committee or in subsequent actions, they'd be able to work out a lot of the details that were still being ironed out. Now, what put a real wrench in these works is that in the special election, in a rather surprising election, a Republican wins the Massachusetts special election, and Scott Brown then takes Senator Kennedy's seat. So instead of a 60-40, you have a 59-41. That's critical because now the Democrats no longer have the supermajority, and the Republicans can filibuster any efforts. So in March, the Senate used a parliamentary procedure, budget reconciliation, to pass the ACA when they only needed 51 votes without the risk of a filibuster. Now, the nuance here, which is critical, is that they couldn't make changes in it. If they made a change, it'd go back for a vote, and they no longer had the filibuster-proof vote. So there were no changes made in the House version. That's the version that was signed by President Obama. I believe today is the 11th or the 10th anniversary of the signing of the ACA. If it's not today, it's right around today. So it's kind of a serendipity we're talking about it on the 10th anniversary. almost immediately you began to see a lot of lawsuits being filed, challenging the constitutionality. As people remember, this was a pretty contentious piece of legislation. And we're cutting through a lot of the toing and froing that lawyers like me enjoy. But in NFIB, the National Federation of Independent Businesses, V. Sebelius, who was Secretary of HHS at the time, first ruled on the Accountable Care Act and upheld the ACA, ruling that the individual mandate is a tax. Supreme Court next dealt with the ACA in 2015 in King v. Burwell. This was not a constitutional case, this was a statutory interpretation. Fast forward, we have another election. In 2017, you have the Republicans in control now of the White House, the Senate, and the House, and the Tax Cuts and Job Act is passed. And among a variety of provisions, this zeroed out the penalty under the individual mandate. So by statute now, there would never be a tax, a payment, a penalty, call it what you want, under the individual mandate. Shortly afterwards, February of 28, a number of states with Republican governors filed suit in Texas, claiming that the ACA is unconstitutional now post-2017 because the zero penalty for the individual mandate. And one can speculate whether this was a long-term strategy to zero it out and then use that as the basis for a second constitutional challenge. There's then a bunch of toing and froing with the Department of Justice changing positions, because you remember also then in 2018, midterm elections, the Democrats take control of the House. And so you have this, again, change in political structure. December of 2018, the district judge in Texas ruled that the ACA is unconstitutional, the individual mandate, rather, is unconstitutional because it is no longer a tax. And we'll get into why that's important in a second. The other vital thing is the judge also ruled that the other provisions of the Accountable Care Act are not severable from the individual mandate. And therefore, if the individual mandate is unconstitutional, the entire ACA is unconstitutional. And we'll spend time on this because this is, in a sense, the critical question. And I recognize this sounds like a nuanced legal argument, and it is, but in this context, it is critical to the future of the ACA. Obviously, this district court opinion gets appealed. December of 2019, the Fifth Circuit finds the individual mandate is unconstitutional, agreeing with the district court, but remands the case, sends the case back to the district court to reconsider the ruling on severability. A number of entities sought Supreme Court review, even though the case was going back to the district court. And just a couple of weeks ago, the Supreme Court agreed to hear the case, now titled Texas v. California. Now, when you think about the ACA, there are some broad themes. We're not going to get into the details of the ACA. That's obviously a very complex bill. But when you think about it, it does a number of things. It's an effort to address obtaining coverage. It's an effort to address keeping coverage once you have it. This is like non-discrimination, economic support. It's an effort to control insurance costs, mandatory ratios, out-of-pocket payments. It's also an effort to ensure that certain services are covered, preventive care, certain types of preventive care, for example. And it's also an effort to provide a lot of information to patients, consumers, et cetera, and to provide them with protection. So you have these broad themes. Now, it's a mammoth bill, over 900 pages long, and has a constellation of complex healthcare provisions. These are just examples. The individual mandate, coverage for pre-existing conditions, coverage under your parents under certain circumstances, their policies to age 26, community rating, Medicare changes or expansion, 80% spend requirement, et cetera. The bill also included a number of non-direct healthcare provisions, nutritional labeling, biosimilar regulation. Once you have this major piece of legislation going through, it becomes, in Washington, D.C. terminology, a Christmas tree, where people hang on ornaments, things they want, that just rides along. So you have these non-healthcare provisions there as well. And since passage and signing in 2010, there have been some changes. For example, the medical device tax, which was part of the ACA, has now been repealed. So what's round one? And we need to get into round one because it sets the stage for round five. Without round one, round five makes no sense. And this is the first legal challenge. This is NFIB v. Sebelius with the 2012 Supreme Court case. And in this case, the focus of the judges was on the constitutionality of the individual mandate, or the shared responsibility payment as it's also known. And this is based on the following challenge. Insurance is obviously based on spreading of risk. And in health insurance, for it to be sustainable, you need both healthy and unhealthy individuals. You need to have a broad risk pool. And yet healthy people, often younger, may not buy insurance. They're not at the life point where they think they need it. They're just getting started in careers, can't afford it, any one of a number of things. So the individual mandate was put in place to require people to have insurance or to pay a penalty. And I'm using this in quotes because the key here is, what is this payment? Is it a tax? Is it a penalty? Is it a shared responsibility payment, or whatever? And this was an effort to make the risk pool more sustainable. And this was challenged on really three grounds, two of which are most important. The clause that everybody paid attention to and thought was the crux of the case is the Interstate Commerce Clause. And remember that Congress cannot enact any legislation unless it has constitutional authority to do so. And so the one that everybody paid attention to was the Interstate Commerce Clause. Congress has the authority to regulate commerce between the states. And this is the basis, for example, for all FDA authority, or the Federal Aviation Administration. It's interstate commerce. Why can't Minnesota put a tariff on cheese from Wisconsin? Interstate Commerce Clause prevents it. Now, there was a side argument that almost all lawyers just poo-pooed, which was the taxing authority. Congress has the authority to levy taxes, right? They do it all the time. And related to these is the so-called necessary and proper clause. This is constitutional law stuff, folks, and it's pretty nitty-gritty, but it's critical. And under the necessary and proper clause, Congress has the power to make all laws which shall be necessary and proper to execute the powers vested in Congress. And so the primary argument everybody paid attention to was the interstate commerce argument. And this focused on the individual mandate. This was a penalty for lack of insurance coverage. And here the argument was that Congress is not regulating commerce, they're regulating a lack of commerce, a failure to enter into interstate commerce. It's clear once one engages in interstate commerce, Congress has authority to regulate it. But if I don't engage in interstate commerce, does Congress have the constitutional authority? The opponents argued that if the Commerce Clause authorized oversight of non-commerce, there were no boundaries to the Commerce Clause. Justice Roberts had the famous analogy, this means the government could, make me pay a penalty if I don't eat broccoli. And you see how the concept here is, does the Commerce Clause give authority for positive actions when I do engage, or is it more expansive and it regulates when I don't engage in commerce? And if it's the latter, there's this fear that it now becomes boundless. And constitutional authority is almost never considered to be boundless. On the other side, people argue healthcare does impact interstate commerce. And if you take a broader look at it, it's clear that interstate commerce directly impacts healthcare. and healthcare directly intersects it. Now, the kind of the backup argument that people raised that didn't get a lot of attention was the tax authority. And is this constitutional under the Congress's authority to impose taxes? Is this penalty really a tax? After all, if you read the statute carefully, it's governed by the Internal Revenue Service. It's part of your tax return. And it has some of the standard features such as the amounts based upon your income. In a splintered decision, 414, Congress upholds the constitutionality of the ACA. But how they did it is critically important. A majority of the judges, 5-4, ruled that the individual mandate cannot be sustained under the Interstate Commerce Clause. Congress, in other words, cannot regulate a failure to engage in commerce. They regulate if you do. And everybody thought if that was the issue, end of story, the ACA is unconstitutional, at least the individual mandate is. But Justice Roberts, in a rather controversial move, then ruled with the 4 judges, the liberal judges, to make a different majority, again 5-4, that the individual mandate is constitutional under the taxing authority, that this shared responsibility payment is actually a tax. And that gave it the constitutional authority. So hence you see this 414. Once we find it constitutional, a bunch of other issues become moot, severability, for example. Bottom line, the ACA stayed in place. And this is kind of how it looks graphically, right? On the interstate commerce, you have 5 no votes for the standard conservative justices joined by Roberts. And the yes, in this case in the minority, are the 4 so-called liberal justices. And you see Roberts then is the swing vote on the tax authority question. You have the same 4 people saying it's unconstitutional, also under the taxing authority, the same 4 judges saying it is constitutional. Roberts upholds the ACA by switching from a no on the interstate commerce to a yes under the taxing authority. So post-2012, the constitutional basis for the individual mandate is the taxing authority, not the interstate commerce authority. That's round 1. We're going to go through round 2 very quickly. That's the King v. Burwell case. This gets into a statutory challenge. We just have this here just for completeness, and whether you get tax credits if you are participating in a federal exchange as well as a state exchange or just a state exchange. The ACA was upheld here on a basis of a statutory interpretation. It was not a constitutional law case. It was a statutory interpretation case. So when we get to later challenges, you don't hear a lot of discussion of King v. Burwell because it's not a constitutional challenge. So round 3, and this is the 2017 when Congress amends the individual mandate. And what Congress did is they went in, kept everything there in the language about the individual mandate, except they set the number to 0. Stated differently, it was never possible for anybody to pay a dime under the individual mandate. And this removed the risk. The other core provisions of the ACA remain. Now, there have been other changes over time, but they're not relevant to our discussion today, so we're really not going to get into those details. Now, Congress knew of the NFIB ruling when it made this change. Is this evidence of the congressional intent to overrule the ACA by zeroing out the individual mandate, therefore creating the argument there is no tax? And that's an open question as to the impact this has on assessing congressional intent. So that now we get to round 4. In round 4, the current constitutional challenges to the individual mandate. And this, as we've talked, this is the lawsuit filed by a number of states and several institutions in federal court. Department of Justice at first is defending the statute, then they're not defending the statute, or they're defending parts of the statute, all because of changing political environment. Because the Department of Justice was not fully engaged in defending the statute, a number of states, including California and Minnesota, by the way, intervened to support the ACA. And this lawsuit asserts really two key things, although there's a third question we'll get to in a second. The lawsuit says the individual mandate is no longer constitutional because it's not a tax. There's no penalty, there's no payment. Those are the core aspects or criteria for being a tax. It's not a tax because the interstate commerce argument was rejected by the Supreme Court 5-4 in the NFIB case in 2012. The tax basis no longer applies because there is no tax. The plaintiffs, state of Texas among others, went on and said, therefore, the entire ACA is unconstitutional. If the individual mandate goes, the entire statute goes. So we had three key questions. First, and this is a technical legal question, we're going to pass over this because it's interesting to kind of legal nerds like me, but not to normal people. And this is a standing question, a ripeness question. Do the states have the right to challenge? Are the individuals appropriate? It's an important legal question, technical, not key to our discussion. So the two we'll focus on. Is the individual mandate still constitutional? And this hinges on whether it is a tax, even though the amount is by law zero. Then the next question, if it is unconstitutional, what happens to the rest of the ACA? And this is what we will call the severability question. And we'll spend a lot of time on severability because as you think forward, that will be the key question. So what did the district court find? They found that there was standing, i.e. the case can proceed. They found that the individual mandate, as amended in 2017, is unconstitutional. Pre-2017, the district court didn't say anything about the constitutionality. It was a statutory change in 2017 that created the constitutional argument. It's not a tax. There is never a payment. And because the interstate commerce argument had been rejected by the Supreme Court, the tax authority was the only basis. This is no longer a tax. Therefore, that reason for upholding it disappears, thereby eliminating constitutional authority for the individual mandate. Then they got to the question the judge did of severability. And this is a tough question for judges. If one part of a statute is unconstitutional, what happens to the rest of the statute? And there are several approaches here. Occasionally, Congress will explicitly address it by saying things like, if one part of the act is found unconstitutional, the remaining provisions shall be in force. That answers the question, you know legislative intent. That doesn't exist in this case in any way that is outcome determinative. Then you got a couple of questions courts generally ask. What would Congress want to happen if this provision became unconstitutional, was deemed unconstitutional? And there the court is trying to, in a sense, guess or interpret what Congress would have done in a fact pattern that they didn't face. And that's a bit of an existential or philosophical endeavor. The other question they ask is whether the elimination of a particular provision undermines or undercuts the ability of the statute to achieve its essential purpose or to operate. Can the statute still work without this provision? And the district court found that the individual mandate is not severable. What that means when we say it's not severable is the rest of the ACA is therefore also unconstitutional. It goes. The judge found that the individual mandate was essential to the ACA. This is kind of that last test that I talked about. In doing so, the judge relied upon things such as statement of President Obama, members of Congress, other commentators, about how the individual mandate is essential. And we'll come back to some language in court decisions in a second that the judge used to support, also used to support that conclusion. And therefore, under this reading, the entire ACA disappears. This includes all the provisions such as pre-existing conditions, the exchanges, access to insurance, etc. And the major impact of the district court decision is this severability. The individual mandate was already zeroed out. It disappears. It's probably only a minor hiccup. It's the severability that has the potential for the dramatic result that this could lead to. And this gets into the question also, what did Congress intend? So, as you can expect, this gets appealed up to the Fifth Circuit. And the Court of Appeals relied solely on NFIB to determine that the individual mandate is unconstitutional. The other cases we've talked about, King v. Burwell, for example, were not deemed to be relevant. NFIB is the case the Supreme Court, in which the Supreme Court established the constitutional basis. And the key to the constitutionality of the individual mandate is whether the individual mandate or shared responsibility payment is still a tax post-2020. Excuse me, post-2017. And the court ruled in a 2-to-1 decision that it's not a tax. And they said it doesn't meet any of the standard criteria for being a tax. It's not being paid by the taxpayer. It's now at zero. It's not collected by the IRS. There's nothing to collect. You don't use standard tax considerations such as income, number of dependents, filing status. And the core, it doesn't generate any revenue. And the core aspect of a tax is that it generates revenue. So therefore, because none of these exist, particularly it doesn't generate any revenue, it is not a tax. And the court was also concerned that if you could create a quote tax, set it to zero, that gives Congress a very convenient way to avoid any limits, any constitutional limits on its authority. I will regulate something that I may not have constitutional authority. I will impose a quote tax if you don't do what I say. I will then make that tax be zero. I have bootstrapped my way into jurisdiction, into authority. And that bothered the majority judges in the Fifth Circuit. And this gets back, we got to remember that you can't use the Interstate Commerce Clause because that was rejected by the court in NFIB. Now, they then moved on to the severability. And remember, the district court said everything was severable. The Court of Appeals was not comfortable with that. And remember, this is a 900+ page piece of legislation. There are a number of provisions such as nutritional labeling that aren't directly connected to the core aspects of the ACA. And so the Court of Appeals didn't think that the district judge had actually analyzed severability in enough detail. And so sent it back down to be reconsidered, the severability, not the constitutionality, but the severability decision. Now, rehearing was sought, that was denied. And so in the remand, the district court must explain with more precision why or which provisions are not severable. And it has to have a level of specificity. You have to have a rationale, and maybe you go through provision by provision, maybe you go through by substance, doesn't matter. But you have to go through that process. And this is really to make the district court rethink this. Now, there are a couple of, just for completeness here, a couple of other issues popped up at the appellate court. In particular, the government raised a couple of new arguments because, again, of changing administrations. Some of the positions had changed. And there was also a debate about the geographic scope of the ruling. Would it just be limited to those states that were involved in the litigation? Those remain open. Right. Now, so here you have two possible ways for this case to proceed. One, it goes back down to the district court. It would take the district court a year or maybe a year and a half, guessing, to come up with a severability decision. Would have to take evidence, write a detailed decision, etc. Or you could seek Supreme Court review. In this case, the people defending the ACA kept all their options open, so they sought Supreme Court review. This is discretionary. The Supreme Court does not have to take the case. This is the so-called petition for writ of certiorari. And there's a question whether the case is even ripe for Supreme Court review. Remember, it was sent back to the district court. District court has to rule on it. So do you have a final decision? And the severability impact is still open. However, a couple of weeks ago, March 2nd to be precise, the Supreme Court agreed to hear the case. I think they recognize the importance of this issue to the nation. And this is really before COVID-19 became as big an issue as it is today. There have been efforts to get expedited review. Those have been denied. So this will be part of what we call the October term. They have a kind of a spring term and a fall term, just like universities do. There'll be briefing, then oral argument. In all probability, we will not have a decision until after the November elections. So what do they have to answer? They'll have to address the standing question. Again, there's a lot of detail there we won't get into. The reason I'm raising this is an opportunity, if the court wants, to duck the substantive issues. Courts often like to avoid constitutional questions if they have another vehicle, another way to decide the case without getting into constitutional issues. But assuming they find standing and that it's ripe for decision, they have to decide, is the individual mandate constitutional if the tax is set to 0? And this is a repeat of the question the district court and the appellate court both answered in the negative, that it's not constitutional. And this links back to the discussion the Supreme Court already had in the 2012 case NFIB. But then if they find it is not constitutional, they have to answer the severability question. And that really has not been directly addressed by the court. Okay, so the severability is the key here. In a sense, because the tax is 0, whether it stays or goes will have only modest impact. The severability addresses the entire act. And in thinking about this, the Supreme Court has to address kind of the historical questions. You know, what's the intent of Congress? In other words, would Congress have enacted the ACA without the individual mandate? And can the statute still operate without the individual mandate in a manner consistent with the intent of Congress? What's interesting here is that right now there are 2 non-healthcare cases pending in front of the Supreme Court raising questions on what is the legal standard for severability. So it may be that these other non-healthcare cases will help answer the question of what is the standard to use, what's the legal test to determine whether something is or is not severable. The other interesting challenge here is that 2 justices, Justice Thomas and Justice Gorsuch, have challenged publicly the validity of the 2 tests I just laid out earlier, which is what's the intent of Congress, will it still operate in the same manner Congress intended? And they question whether that's outside of the ability of a court to decide. And Justice Thomas, who's been on the bench for many years, has long been reminding people that he disagrees with this test. In a recent publication, Judge Gorsuch appears to have the same concerns that Justice Thomas has. So these are a couple of justices that are questioning, or at least arguably trying to rethink what the standard is. Now, what about the severability here? And this gets into, is it a tax? That's kind of the first question. And what the majority opinion in NFIB said, it is a tax, because at the time, this is 2012, before it was zeroed out, it's paid to by the taxpayer when they file their tax return. If you don't pay federal taxes, you're under the threshold, you don't pay. These are all the indicia of a tax. If you do owe a payment, the amount's determined by kind of standard tax issues such as what's your taxable income, dependents, filing status, etc. The requirement to pay is found in the Internal Revenue Code. It's enforced by the IRS. It's collected, quote, in the same manner as taxes. And then the process yields the essential feature of any tax. It produces at least some revenue for the government. That's a quote. Okay, it produces at least some revenue. And you can see where the argument's going. If I make the dollar amount by statute 0, where no one will ever pay a dime, it cannot produce any revenue for the government. So therefore, is it still a tax? So I think you can see how the arguments line up on whether or not it's a tax. Then you get to the question, how integral is the individual mandate to the other provisions? And this is what a couple of the decisions, opinions said in NFIB. The three of these issues of guaranteed issue, community ratings, exacerbate the problem of healthy individuals foregoing coverage until they become sick. The individual mandate was Congress's solution to the problem. Sounds like it's important, right? Other side, failing to invalidate major provisions would create significant risks and uncertainties on insurance companies, customers, blah, 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 all in absolute conflict with ACA's design of shared responsibility. So kind of everybody in 2012 seems to be talking about the importance of the individual mandate in the operation of the ACA. Now, as we've mentioned, 10 years have gone by in which, for all intents and purposes, the individual mandate has never been enforced. And you can argue the ACA, whether you agree with it politically or not, is not an issue for today. But it's worked kind of the way Congress thought without the individual mandate. So does kind of that real life experience, can it work without the individual mandate? Determine whether or not it's essential to the operation, which is one of the tests. Again, we're putting Thomas and Gorsuch to one side. It's one of the standard tests. You still have the question, would Congress have enacted it without the individual mandate? That question is still open. But you see now the link, the critical link between the NFIB case, 2012, and the case the Supreme Court's going to hear, in October of this year. So let's look at the composition of the court. NFIB, Scalia and Kennedy were still on the court. The four dissenters on the tax question, Scalia, Kennedy, Thomas, Alito, only two of those are still on the court, right? Thomas and Alito. Now we have Gorsuch and Kavanaugh replacing Kennedy and Scalia. And if you look at the lineup, conventional wisdom says, oh, Gorsuch and Kavanaugh generally line up with the so-called conservative wing, i.e. the Alito-Thomas group from the initial decision. But remember, Gorsuch has already questioned, as has Thomas, the historical severability jurisprudence. And that makes a lot of prediction here much more difficult. You have Roberts, who went out of his way in many people's minds to find a constitutional basis for the statute by finding the taxing authority, is still on the court. And you still have a number of the other players, Justices Ginsburg, Sotomayor, Kagan, for example, are all still on the court. And so the lineup has some interesting similarities, but some interesting changes. And will Roberts still be willing to find the individual mandate a tax when it's been zeroed out, and the essential aspect of a tax being that it generates revenue now being an impossibility? All of this goes to the first question of constitutionality. When you get to the second question of severability, Thomas and Gorsuch are a bit of a wild card now, particularly Gorsuch, because we don't have a lot of jurisprudence from Justice Gorsuch on severability. Thomas has already said he doesn't like the test. And you have, in addition, 10 years of real life experience under the ACA, which the justices may well take into account. So this is where we're lined up right now. Guessing Supreme Court timing is always dangerous, but not as dangerous as guessing what they're going to do. But the best predictions on timing is they will not issue a decision until after the election, probably Q1 of 2021, year from now, or a little less. It's very unlikely they issue it before the election. The oral argument will probably take place in October. The election, second Tuesday of November. Be very surprising if they got a decision out before then. When the court denied expedited review, that strongly signaled they were not going to have their timing influenced by when elections were. And from their perspective, there are a lot of reasons to wait and no reasons to accelerate it. In terms of decision, the tax question is going to be a difficult one. I think for the supporters to argue, there are some arguments. The severability is a much more interesting and difficult question. And I've mentioned there are 2 Supreme Court cases, neither are related to healthcare, which are currently pending. Those 2 cases, when they come out, and I'd expect those to come out in the June timeframe, absent COVID-19, will shed a lot of light on what will happen with severability in the current Texas v. California case. So what's round 5 then? And that's how should stakeholders, whether you're a provider, a payer, whomever, react to this a level of uncertainty. And as we've thought about it, there are kind of 4 potential pathways. Assume the court has found the individual mandate to be unconstitutional. Option 1, they can find it completely severable. No impact on the rest of the ACA. And in this case, there'll be maybe a little bit of impact on some individual markets, but it's going to be a minor blip on the radar. And, lawyers will talk about the interesting legal issues, people in the real world. This will not be an issue. The second option is a narrow severability decision. And that is, as you saw from the earlier slides, in the earlier cases, there was specific discussion of the linkage of the individual mandate to the guaranteed issue and community rating. The court could lump those together in just a narrow bucket of 3 issues and strike those down. That's going to have a bunch of issues on the individual mandate, on the individual markets, and how those play out both at the federal level and at the state level. The third option is that the severability brings into play the major provisions of the ACA, all of the insurance, Medicare, Medicaid provisions, offsets, etc. Basically, most of the healthcare provisions. This would create substantial change in the healthcare marketplace for carriers, providers, consumers, etc. And the fourth option, if there is a substantive decision, is that the entire ACA gets struck down. And this would include all of the non-healthcare provisions, such as biosimilars, provisions dealing with nutritional labeling on like restaurant foods, those kinds of things. Now, the Supreme Court can make this decision itself. They can say, here is the test for what is and is not severable, and we therefore rule these provisions are in, these provisions are out. The court can also take a different approach. The court can create the rule or reinforce what the rule is. Here is the standard by which to assess whether something is or is not severable. and then remand it back to the district court for the district court then to collect evidence, hear witnesses, briefing, whatever, on how to apply that test. If that's what takes place, then we're in for several more rounds. What that means is, let's say in February of 2021, the Supreme Court rules individual mandate is unconstitutional. Here is the test for determining severability. We are remanding this back all the way to the district court for the district court judge to redo its ruling in light of this test. It will take a year plus or minus for the district court to do that, probably a year. So then we're all of a sudden in 2022. No matter what the judge there decides, it will get appealed back to the Fifth Circuit, another year there, so we're in 2023. All likelihood, absent congressional action, people then seek Supreme Court review. So it is not at all unlikely that if the Supreme Court strikes down the individual mandate as it is no longer a tax, we'll actually be back in line for another 3-year plus or minus cycle as this gets sorted through. Now, a couple of things. These are other levels of uncertainty. We don't know what the decision will be. The Supreme Court can duck these issues on some procedural grounds. We also have an election coming up in November, and we've already talked about how the position of the government, Department of Justice, has varied depending upon who's in power. So this, A, could impact the position the government takes, but also under some scenarios, let's assume hypothetically that the Democrats control the White House, the House, and the Senate, they can make statutory changes to address these various issues. So there could be differences in the position the government takes in litigation. There could be statutory changes, all depending upon what the outcome is of the November elections. There are economic factors here. The extent of the disruption of COVID-19 is unclear right now. How that will impact health insurance. Congress is working on major stimulus bills. Disrupting the healthcare ecosystem at this difficult time may be something that nobody in Congress wants to do. And then you have public payers, Medicare, Medicaid, kind of state level, federal level programs. They don't have to always do identical things here. So there may be variations within states, and then private sector responses. So the timing, and this is just more detail on the timing so you can start thinking about how this plays out. We've covered some of this. Decision probably early 21. No expedited case will take place. There's an extended briefing schedule. There was a motion filed just on Friday to extend the briefing schedule. I anticipate that being granted, particularly in these circumstances. They're clear in that that will not change oral argument. Oral argument has not yet been scheduled. So as a practical matter, everybody's going to be making healthcare insurance decisions for 2021 before we know the ruling. And so this has happened before. What the courts have done, recognizing they can't disrupt the healthcare system just on one ruling, is they have delayed implementation or just delayed the effective date of rulings, giving people a chance then to modify their activities in light of whatever that ruling would be. I would anticipate that taking place here in this situation. Now, the other thing to think about is whether some of the provisions or many of the provisions of the ACA may now be generally accepted by the broad population, and that these will stay in place kind of regardless of statutory mandates. So does the health insurance marketplace now expect or demand coverage for pre-existing conditions, dependent coverage to age 26, some insurance exchange program, preventive services, all of those kinds of things? And so even without the ACA, would private insurers, employers, for example, just because of the marketplace, need these provisions because that's what people have come to expect. So the passage of time can also make some of these issues less critical because people expect them apart from statutory mandates. And this can be the same thing, on the Medicare, Medicaid, the public payer. Have we just gotten used to these? It's hard to unring a bell. Now, there are some more specific things that can be done. As we mentioned for 2020, and remember these decisions were in 2019 and late 2018, health plans already have addressed this in their 2020 plan years. And they will have to do the same thing for 2021. Rate setting activities, begin mid-year. And so people just have to operate on the assumption that nothing will change for 2021. If there are changes, states can use waiver authority under Section 1332 to really establish their own coverage mandate or risk pools, reinsurance pools, et cetera. The other thing that can take place here is that Congress can come in and they can try to reduce or eliminate the uncertainty by statutorily determining what is or is not severable. So going back to a discussion we had, if you believe that, or if the Democrats sweep the November elections, the case is still pending in front of the Supreme Court. It would not be surprising to see Congress, pass an amendment to the ACA that says none of these provisions are severable. And courts will probably go along with that legislative intent if that's at all rational. So going forward, yes, there's going to be a period of uncertainty among plans, providers, et cetera. We've been through this uncertainty before, and people have operated as if the rules are not going to change because they really don't have much of an option, and also on the belief that courts and or Congress will not permit a mid-year complete disruption of the healthcare system. So we have an interesting number of months here. We will see some hints as to probable directions of the court in some of these other rulings, but we'll really probably have to wait until next January, February, that kind of time frame, maybe December, to have a lot more certainty. Between now and then, we will have an election. We will have hopefully more clarity on the COVID-19 situation, and we'll have another year of experience with the ACA and people becoming, frankly, just accustomed to a lot of the provisions that you find in the ACA. This has been a rather detailed discussion of a complex legal issue. Hopefully it was useful to help put it into context, and open it up now for any questions, comments, or other thoughts.
So if you do have any questions, feel free to submit them through the Q&A text box. We do have someone, Ralph, who is interested in hearing your thoughts and insights on the latest news that President Trump may try to leverage the ACA for those who are anticipated to become unemployed or who are already unemployed and in need of health care benefits.
Correct. This is part of the COVID-19 response and trying to, I'll use the term stabilize the economy to restore consumer confidence. My best guess, emphasize it's a guess, is that neither party and neither the executive branch or the legislative branch wants to see major uncertainty in healthcare. And so I certainly think that's a possible route that the administration could take and that Congress would at least be very interested in supporting.
One quick note, there was a comment asking whether, thanking this for this great overview, Ralph. Thank you so much. But question was whether we will make this available recording online. We are recording this webinar, and we can make it available on our MILI website, and Kim can send more instructions to those who are registered.
Other questions? Other comments? What have I missed?
I have one question, Ralph. This is Pınar Karacamandic. So I'm asking this question more from coming more from an empirical researcher. So you mentioned several times that can the court handle a test? I mean, when you talk about court doing a test on the severability, for example, I mean, essentially it's kind of testing whether the law can stay and function as it's intended in the absence of the individual mandate, right? That's kind of the test. So when I put my empirical hat on, we can empirically test for it, because, you know, it's actually, we actually have now data since the Jobs Act, when the tax penalty was, you know, kind of moved to $0. So how would the court respond if empirical perspectives then say, well, let's look at the data. Has the law been functioning as intended in the absence?
Generally speaking, the court these days will consider relevant empirical data. The process of getting it in front of the court is either an amicus brief or one of the parties included within their briefing. As a historical note, the first time empirical data was used with the court was 1954 by Thurgood Marshall in arguing Brown v. Board of Education, where they actually used empirical data on the negative impacts of segregation to undercut the old discredited Plessy v. Ferguson separate but equal. So there is now a 60-year history almost. Actually more than 60-year history of using empirical data if you can establish relevancy of it and if it has sufficient validity. One of the questions the court will have is, has enough time, we basically have 2 years, 2018, 2019, is that enough time for there to be, you know, empirical research that's actually meaningful? And that's a question for researchers more skilled than me. I would not be surprised if people tried to. Other comments?
Yeah. Well, there were a few comments. Thanking you very much, Ralph, for the overview. That's just such clarity, this complex and long history. Thank you.
My pleasure. I hope it's useful for folks. It's a fascinating topic for those of us who play in both the law and the healthcare area.
Well, if there are no other questions, thank you so much again for all of you to join the webinar. Oh, there is maybe one more cute question that's, oh, very useful. Well, thank you so much.
I appreciate it.
Excellent presentation as always. Thank you. And it's great to have you back, Larry Cosisto. Thank you very much. And yes, please stay in touch with MILI. We will have these lectures and webinars throughout this period, all in virtual setting. And yeah, thank you so much for joining us. And thank you so much, Ralph, for sharing.
I appreciate everybody's attention. Thank you very much.
Have a great afternoon.